Okay, well, we're setting up the presentation. Maybe a question from my side. How many of you represent brand owners? How many of you in the room? It's already quite a few. Yeah, that's good. So I'm going to talk about IP protection and enforcement in the new generic top-level domains. A bit of hooking on to what the previous speaker said, looking at what happened on the top level, and then looking at IP protection at the second level. Second question from my side, does anybody know the book, The Paradox of Choice by Barry Schwartz? Yeah, some of you may have read it. Well, in The Paradox of Choice, so Barry Schwartz is a PhD in a lot of psychology-related aspects, and he teaches at the Berkeley University. He wrote a book about how do people choose. And one of the things that he said, he did a test a couple of years ago. He selected in Berkeley, he selected a very small shop, grocery store, and he said, well, let's give it a try and see how people make selections on which type of stuff that they want to put on their sandwich. And he basically handed out discount coupons for jars of jam. Yeah. And so for every jar of jam that you bought, you could get a $1 discount. And there were 4 jars of jam sitting in the racks. And what did you see in the end of the day? At that point in time, they clearly saw that the number of jars of jams that were sold increased dramatically. A couple of months later, this is supply and demand, so this is basic economics. A couple of months later, he did the same exercise, but he put 42 different types of jars of jams in the racks. What happened? Again, they handed out discount coupons. You would say, again, supply and demand, so more jam would be bought. Everybody started buying peanut butter. So the moral of the story is actually the more choice that you make, the harder it becomes to make that choice, and quite a few times, people simply do not choose. So let's go into the recommendations straight away. The recommendations that you will get also at the end of the speech is, first of all, devise a clear strategy. We've seen about 1,500 TLDs will go live in the next year and a half. Many of you have participated in sunrise processes. So that basically, if you drill it down, about 1,000 of those 1,500 top-level domains are open, so you can register domain names in them. So you need to choose. That would mean, for the next year and a half to 2 years, about 2 sunrise processes a day. Yep. So this is the complexity. Will you register in every top-level domain? Probably not, so you need to make a clear choice. ICANN has devised new rights protection policies and processes in connection with the new gTLD program. So you probably will need to use them to a certain extent, but also take them with a grain of salt. And 3, definitely looking at the sheer number, the sheer amount of increase in new top-level domains. We're basically going from 350 country codes, generic top-level domains altogether, to about 1,800. So we're multiplying the whole route by 5. It's probably, this is the time to increase your risk appetite. Yeah? Not going after every TLD that could create or cause issues from a trademark law perspective. 2 aspects. So first of all, legal rights objections. So we've heard the previous speaker talking about those processes. One of the pre-delegation objection processes were related to trademarks. So the legal rights objection procedure that was put in place, where you could file a complaint before the World Intellectual Property Organization. Many of you will know that organization because it also administers most of the complaints under the Uniform Dispute Resolution Policy. And March 13 was basically the final date for filing such an objection. What do we see? For trademark owners alone, so we're not talking about the 3 other categories of objections, about 69 compliant objections were filed. 5 of them have been terminated by the objector. 4 objections only have been upheld. So this was a mechanism created specifically for brand owners to protect their trademarks at the top level. Only 4 of the 69 cases that were filed were upheld by WIPO. So 59 objections in total have been rejected. Now you may say, okay, this is a process or a procedure that has been specifically designed for facilitating brand owners. What do we see? That was pretty difficult in most of those cases for the trademark owner to establish the likelihood of trademark infringement in those new TLDs. And that was especially the case when the TLD applied for was a dictionary word. Yeah, so some may say a generic word, but it's actually a dictionary word. If you go through the list, all the objections, all the decisions are published by WIPO on their website, and you will see that most of the cases relate to those. So it's a mechanism that has been put in place. Was it effective? Was it really alleviating the concerns of brand owners? I'm not quite sure. Look at the sheer numbers. That will give you some kind of an impression. If we're looking at IP protection at the second level, there's much more to do about that. Of course, not everybody could cough up the $185,000 for applying for a new top-level domain. So the vast majority of brand owners were looking at what is going to happen on that second level. Yep. Vast majority of brand owners, also quite a number of big ones, were just sitting on the fence saying, well, look, what is going to happen with this new gTLDs? And maybe we're going to participate in the next round, but since there is no real hands-on experience in how do you manage a .brand top-level domain, let's wait and see. So the main focus now, since the objection procedures are over, the main focus is now, how are you going to protect your trademarks at the second level? And some cases, or some processes have been developed by ICANN. The first process is the mandatory sunrise process and the IP claims process. The second one is the uniform rapid suspension. The third one, it's not really developed recently, it was developed in 1998. That's the Uniform Dispute Resolution Policy. That's the first policy that ICANN ever developed. ICANN was established in 1998. You have the post-delegation dispute resolution procedure. I'm going to briefly touch upon that. This is basically when you see that a registry is involved in systemic trademark abuse. You can basically file a complaint against the registry directly. Now, when you see that somebody else has registered your trademark as a domain name and is doing funny stuff with it, at that point in time you go to WIPO for UDRP or to the American court for the UDRP. If you see an issue in .be, you go actually 2 floors up from here, which is CPINA, for dealing with the .be dispute resolution. If you see an issue in .eu, you go to the Czech arbitration court. But these proceedings are directly against the domain name holder. If you see that there's systemic trademark abuse, the PDDRP, we like acronyms with ICANN, the PDDRP actually allows you to go directly to the registry, and that can result in termination of the registry agreement. So it's a pretty strong stick that brand owners may have if they see that registries go AWOL. And also, there's a complaints point of contact. It's a mandatory position function within each registry. So if you see that there's abuse with a domain name, you can go to the complaints point of contact as well. And you will see, historically, there are a lot of provisions in terms and conditions and registration policies that registrants are not allowed to register domain names that are corresponding to somebody else's trademark and infringe those rights. Well, complaints point of contact may be your best way out. So you don't have to spend too much money in order to get your domain names back. If you look at mandatory sunrise processes and IP claims processes, so sunrise is a period, a limited period of time, ICANN has now said, well, it's at least 1 month, where if you have a corresponding trademark, that you can register the trademark before the general public can. Yeah? So this is, you get the first bite of the cherry, that's what it's all about. The IP claims process is new. Some of the registries have implemented it in the past, but now it's rolled out on a global scale within new generic top-level domains. There's a notice that is being sent to the registrant when that person registers a domain name that corresponds to a trademark. Yeah. So this is a very important element, but again, take it with a grain of salt. Why? Because it's only a notice that's going out. There's nothing that will happen unless the trademark owner itself takes action. But it's a notification, you get an email, as a brand owner, if you're in a trademark clearinghouse that says, well, hey, somebody registered a domain name that corresponds to your trademark. So that's already good. It's a mandatory monitoring service that is being provided. Now, what is important if you want to participate in one of the two or in both processes? That you knock on the door of the Trademark Clearinghouse. Jan Korstens, with whom I have had the pleasure to work with for various years. He's the next speaker. He will tell you all about it. So you knock on the door of the Trademark Clearinghouse and you basically say, give me an entry ticket. Yeah. Jan will explain more in detail because it's more than a ticket that you get, but basically that's what it comes down to. You get an entry ticket, and then you can knock on the doors of all the registries that have open registration policies and say, I want to have the corresponding domain name. So rather than every registry organizing its own sunrise process, where you have to file documents, where you have to file trademark certificates, where you hop on your left leg and pull your right ear in order to get the corresponding domain name, this is now all being centralized. Yeah, so that's a good thing. Now, there's a but, yeah. First one is there's a fee to be paid for inclusion in the Trademark Clearinghouse. That's one. Two, that doesn't take away that the brand owner also has to pay a fee to the registry if they want to use the sunrise process. So it doesn't stop there. And the point is that we don't know at this point what the charge will be for registration that is being asked by the registry. So theoretically, they can go up to .me, I think, was the most expensive one that charged $1,000 for getting one registration for a domain name during their sunrise process. So theoretically, that can be the case. Yeah. Now, of course, also registries have to pay a fee as well for using the Trademark Clearinghouse themselves. Three, IP claim service is limited to providing notices. So as I said, it's still up to the brand owner to see whether or not they want to take action. Because of course, the system, the clearinghouse will only look at, well, what are the identical and what are the more or less similar domain names that you can generate and that have to be reported by the trademark owner. The Trademark Clearinghouse cannot say, this is trademark infringement and this is not. So you can have false positives and also false negatives. So what I'm actually saying is that this is not a full 100% bullet waterproof solution. So still, as a brand owner, you need to be cautious. And when you see something happening, you go to the processes that are also devised by ICANN. Uniform rapid suspension. So here we're coming into enforcement mode. Yeah. The first one was making sure you're in safeguard mode. You want to make sure that your trademark is not being fiddled with by a third party. You just register your trademark as a domain name, and then in principle nobody else can do that. Yeah, they can register still a variant, but at least your trademark is safe. Here you're entering into the mode where you're going to enforce. You see that somebody else has registered your trademark or a confusingly similar sign and is actually committing trademark infringement. So the objective with the URS, so we have UDRP, I'm going to give you a couple of numbers, a couple of statistics on that later on. But URS, the objective of the URS, the initial objective, was to make sure that the real clear-cut cases of trademark infringement, that you could act swiftly in order to get these removed. Yeah. That idea was put on the table back in 2007 by what is referred to the implementation recommendation team, one of the consultation groups that ICANN established in order to make sure that the concerns from trademark owners were mitigated. Well, what we have here is a temporary suspension of a domain name, hence uniform rapid suspension. In UDRP, as is the case with .be, as is the case with .eu, you can ask for a transfer of the domain name if indeed the panel who deals with the procedure, if the panel determines that indeed the domain name is infringing the rights of the trademark owner, I'm going back to the substantive criteria in a minute. So the difference here is that you do not get a transfer of the domain name. The domain name actually remains with the registrant. The only thing that will happen is that the domain name, when you use your browser and you go to that particular domain name, it will display a page saying, well, this domain name has been suspended under the URS. That's what it basically comes down to. So for the remainder of the registration period, the domain name gets suspended. So you cannot ask for the transfer, which is a bit odd, because the domain name still sits with the one who basically infringed your trademark rights. Uniform dispute resolution, very quickly, because I think most of you know more or less what the substantive criteria are. If you see, as a trademark owner, that somebody has registered a domain name that is identical or confusingly similar to your trademark, if you can establish, and it's most of the time to be done by the registrant, that that registrant has no rights or legitimate interests in a particular domain name, and that you see that the domain name is registered and or, well, here it's or mainly, is being used in bad faith, at that point in time you can ask for the transfer, for the deletion of the domain name. These are your two options. Most, in 99.9% of the cases, registrants ask for the transfer of the domain name, and not for the deletion of the domain name, because, well, if it's deleted, then somebody else can register it, and then you have to do the whole thing all over again. So this is what UDRP is about. Substantive criteria for UDRP and URS are more or less the same. The only thing that you can do is ask under the URS for a suspension of the domain name, whereas under the UDRP you can ask for a transfer. So strictly speaking, the intention was with the URS to, well, with the UDRP in 1999, when the first cases came about, with the UDRP they said, well, we want to have clear-cut trademark infringements. That's what we're focusing on. At this point in time, we're talking about 43,000 cases already, yeah, in a bit more than 10 years' time. Now, why do we need the URS if UDRP was designed for clear-cut trademark infringements? That is basically because under the UDRP, we see that respondents, so registrants of domain names, in just a few of the cases, 15–20%, actually file a response if the trademark owner files a complaint. So the point is there, why does a trademark owner need to pay a high cost to the WIPO or to the Czech arbitration court, $1,600 I think it is, if it's a clear-cut case? And hence the uniform rapid suspension has been developed, where the fees are lower, but the remedies are less appealing. So there you need to basically make an assessment depending on the actual case, whether you're going to use URS, which you have to monitor probably in perpetuum, or whether you go for the UDRP and pay a higher fee. Now the question, and that's why I asked you the question about Barry Schwartz and the paradox of choice, you need to devise a strategy, yeah? I think it will be impossible for the ones that are managing trademarks and domain names as in-house counsels to go to top management and say, well, for a sunrise process, we have to pay about $100 per registration. We have 5 trademarks in our portfolio, so that's $500 per TLD. There's about 1,000 TLDs that are going to go live, so can I have $500,000, please, in order to protect, quote unquote, our trademark? Probably not. Yeah. On the other hand, the flip of the coin is actually doing nothing in an idea. Well, maybe for some it is. Yeah. If you see what happened in the past, and I'm referring to statistics that will come in a minute, a lot of companies have simply said, well, no, we walk away. That's maybe also not the best option. So you need to devise that strategy. You need to look at which trademarks that you have, which are important, and probably all of them are, but are they really important in registering your trademark in .horse or in .ninja, which are 2 applied for TLDs? So these 2 maybe already go out. So you need to decide on what to protect. So where do you participate in sunrise processes? And as I will show you in a minute, maybe it's not really necessary in order to do it. Maybe you can just wait for the next phase to arrive, where most of the time the fees will be dropped, criteria will be less strict. And on the top left corner, when you look at enforcement, well, here is the new trick. Yeah? We don't know what is going to happen. We don't know how appealing these new top-level domains will be for trademark infringers. So you always need to have that stick where you can, well, let's say beat a trademark infringer if necessary. And ICANN has given you a couple of sticks. So you need to get that full picture ready. What do you have to take into account? Yeah, you can, for instance, say, well, look, okay, we want to register our trademarks. We don't want to have a nasty phone call from our CEO saying, well, somebody registered our trademark in .Versicherungen, for instance, which is also one of the applied for TLDs, and is doing nasty stuff with it. Well, one of the things that you have to bear in mind when you're looking at this is, if you just look at the numbers, which I'm going to again show you in a minute, where do we see that most of the trademark infringement is happening in top-level domains? Well, first of all, it's with the well-established TLDs, the old ones, the .coms, the .be's. That's where things are happening. Also, the more domain name registrations that you have, and that's normal, right? That's plain statistics. If your population is bigger than at that point in time, you may get more hits. So TLDs that hold many domain name registrations, like .com, 100 and odd million domain name registrations so far, these are the ones where you see trademark infringement happening. .cn for China was for some time pretty hot in terms of trademark infringement, because basically CNNIC, which is the registry for .cn, handed away domain name registrations for free, so we saw immediately the number of trademark infringements going up. So the more domain name registrations that you have, at that point in time, it's more high risk. Third element, if domain name registrations are cheap, of course, a trademark infringer doesn't want to pay $200 to just infringe your trademark. Yeah? So this is a bit of a logical thing, and you have to factor that in. And why is that important? If you look at history, acquisition of a TLD was relatively cheap. Yeah? .com was given to VeriSign back in the days when they split up with Network Solutions at that point. .be, Professor Pierre Verbaten didn't pay a penny to ICANN in order to manage .be from the KU Leuven back in the days. So at this point in time, when your acquisition cost for a TLD is already $185,000 plus consulting fees, plus whatever you have to pay in terms of procedures and legal and operational and technical management, well, most likely your sale price for a domain name registration as a registry will go up. So hence, you get this negative effect on the appeal for trademark infringers. And also, if you have more complex domain name registration processes and requirements as a registry, you also see that trademark infringement is going down. So, looking at the gTLDs, as I said, the acquisition price was relatively high. That's one. And we see that ICANN has established these far-reaching trademark enforcement rules. So, the net effect of this is that this is a good thing if you want to manage your trademarks. That could mean that you can say, we're not going to register during sunrise in all of the TLDs. Your risk appetite can increase. The likelihood that a trademark infringer will register your trademark and do funny stuff with it in a TLD at a high price is relatively low. So your risk decreases. The numbers that I promised. These are the statistics published by WIPO on UDRP cases. So where in UDRP, WIPO found that indeed there was trademark infringement in a top-level domain, or with a domain name registration. In total, about 45,000 UDRP cases were filed. Hit ratio for trademark owner who files a complaint under UDRP, is about 95%. So the vast majority of the cases, the WIPO and other panels say, well, we're going to award the domain name to the trademark owner because indeed there was trademark infringement. So in the initial TLDs, .com, .net, .org, .edu, which are in this list, we see that 43,000 cases have been filed under the UDRP with a 95% hit ratio. In the first round of new TLDs, back in 2000, so we have there .pro, we have, let me see, .biz, we have .info as examples. The number of cases is going down. And in the second round of TLDs, with more restrictive policies, we see that only 340 cases have been initiated. So the more TLDs that you have, the less risk that you're actually going to incur in the new ones. So there's a clear downward trend. The risk appetite for brand owners in new TLDs is increasing. If you look at sunrise processes, we have the .eu sunrise back in 2005, 2006. 346,000 registration requests from intellectual property owners. This is more than just trademark owners. .mobi, a couple of months later, did 14,000. .asia, a year later, 31,000. .tel, 9,000, 8,000 for CO, 4,000 for SO. So again, there's a downward trend. Which means that the main initial revenue source for registries is going down, whilst their fee is pretty high up. And that means that all these registries, they had the opportunity to talk exclusively almost for a period of about 6 months to a year with registrars to build their channel, to talk to the people who are going to sell domain names to the actual trademark owners. This exclusive airtime will be over. Yeah, with 1,000 open top-level domains knocking on your door, you have to go Barry Schwartz route. You have to make a choice. Now, if you look at these 1,000 sunrise processes, we're talking about 2 sunrise processes per day on average, and this for a period of 1.5 years. If you look at the 100 registration fee per domain name, that's just what the registry is charging, you will see that it will become difficult if you just have one trademark already. That means in initial registrations alone, you need to look at $100,000 US for protecting your trademark. There's little or no competition. This is a very important factor when you consider playing during sunrise. And that's what the suggestion what I made in the very beginning of my speech. About 2% of the trademarks that have applied for a domain name registration during the sunrise process were identical. You have Apple, who has the trademark for iPhone, as we all know, but also Cisco has a trademark for iPhone. So the competition in that phase of now mandatory phase of 1 month will be not as high. It's only 2% where you have identical trademarks. So one of the options could be, definitely if your risk appetite increases, maybe following my speech that could be the case. At that point in time you may decide, well, let's not play during the sunrise process for a domain name, for instance, or for a TLD that is relatively not really interesting to us. Let's protect our trademark during the land rush period, where in principle the fee for the registration is going to lower. And your 100,000 is going down as a budget where you have to apply for with management. So this could be one of the tactics that you could use. How unique is your trademark in the world? And the more unique it is, maybe you should aim for a later stage. So one of the things that we've done, and you can definitely talk to a couple of people in this room, Register.be and Combell, is we've set up a very small tool in order to help you choose. Yeah? Inspired by Barry Schwartz, we said, well, okay, how do brand owners make selections? So this tool, and we're in demo mode, but it will be released pretty soon. You can basically put in your trademark information, including some additional stuff like which products and services do you offer under that trademark. You put that in, and the tool generates, on the basis of that information, a first, very sketchy type of report, a strategy on what you could do. Yeah? Of course, it's a tool. It works on a very simple principle of garbage in and garbage out. So do be aware that this is just technology making suggestions for you. There's, of course, a methodology that sits behind it. But what does it do? It will basically say, well, look for each of the TLDs, depending on the posture of your trademark, the industry where you're in. Yeah? B2C is generally considered more high risk for trademark infringement than B2B, for instance. Apple has substantially more filings under the UDRP than a company like Rio Tinto that is in the mining industry. Yeah? So that is being factored in. And basically the tool gives you a first idea of what is going to happen. And moreover, it's not really on the slide, so it gives you a budget on what you have to spend in each of the next calendar years. Because now you don't know what is going to launch when, what do you have to do in order to protect your trademark. So you don't know what you have to apply for as a budget with management. This is something that helps you for a very little part of the way. Yeah? You can make selections. You can say, okay, Apple.Alsace, one of the applied for TLDs. We're not really into the wine business, so probably Alsace is not really an interesting TLD, so we're not going to register. We're going to monitor that domain name registration, or we're basically going to ignore it, like we're going to do with, for instance, Apple.Bloomingdale's, because Bloomingdale's doesn't sell IT equipment. So these are the different assessments that are actually being made by the tool. Going back to the recommendations, you need to devise this strategy. Not just sit there and say, well, look, for every domain name registration, for every TLD that knocks on my door, I have to do something. You need to plan that ahead. That's very important. The stakes are pretty high, and the budgets are even higher. So do bear that in mind. Consider using these rights protection mechanisms. TMCH, the Trademark Clearinghouse, is a very useful tool. But does it mean that you have to play in every sunrise that comes across? Probably not. Still, you have to use the Trademark Clearinghouse. That's clear. But it doesn't mean that you have to apply and register domain names in every sunrise process that comes across.